Welcome, everyone. I'm very happy that you're joining us today. Welcome to our panel discussion on the topic of artificial intelligence regulation across the world. My name is Ying Hua. I'm the director of the Cornell China Center and a faculty member in the College of Human Ecology at Cornell University. So Cornell China Center, we serve as a bridge between Cornell and China. It is the center's mission to facilitate research collaboration with the goal to bring best minds together to work on challenges, significant challenges that face the world, and to facilitate partnerships for supporting education, learning, as well as to connect with our large community of Cornell alumni throughout China. So it is really an honor for us to work with Professor Xinzhong Yu, who is the Anthony W. and Lulu C. Wang Professor of Chinese Law at the Cornell Law School, and a very knowledgeable panel today on this webinar on the critical issues around AI regulation. Now, I'm going to hand over to Professor Yu to moderate the panel. Professor Yu, please.
Thank you, Professor Wang. Good morning, everyone, or good afternoon or evening. Welcome to our panel discussion today. As Professor Wang mentioned, my name is Xinzhong Yu Xinzhong. I'm the Anthony W. and Lulu C. Wang Professor in Chinese Law at Cornell Law School. In addition to Chinese law, I also teach comparative legal philosophy and a seminar on new rights, cyberspace, and law. Okay. It is my honor and pleasure to moderate this panel today. I'll just say a few words before we get started. The focus of our webinar today is the regulation of artificial intelligence. With the widespread use of AI comes a clear need for regulation at the local and global scales. The European Union has set world standards with its General Data Protection Regulation, the GDPR, and is mulling over an Artificial Intelligence Act. China has developed a series of regulations and rules for algorithmic supervision and accountability. And in the US, a legal framework for regulating AI is slowly taking shape. The US, of course, has adopted a very cautious attitude towards regulating AI. As early as 2016, the Obama administration already began to focus on the risks and the regulations for artificial intelligence. Then the US has made several regulations for artificial intelligence, but due to the First Amendment issues and constrained by the Article 230 of the Communication Decency Act, the responsibility to regulate is largely left to the platforms, but there are more recent new legislation promulgated, basically included in the military budget, state budget of 2021. Okay, so how is the, do these worldwide regulations actually share any strategic similarities or common values? And how is AI interacting with intellectual property rights? How can AI guidelines serve for the purpose of provide accessibility for citizens with disabilities? I'm very excited that today we have brought together this great panel of distinguished theorists and practitioners to address these issues, which are critical to our work today. Now, our plan today is that each of our four panelists will have 10 to 12 minutes to present an aspect of AI regulation, directly followed by 3 to 5 minutes for 1-2 questions. And then we will move on to the next panelist. After all four panelists present, we will have additional time for Q&A altogether. Okay. We encourage you to submit questions through the Q&A Zoom tool during the speaker's remarks. Okay. Now, our first panelist is Rostam Neuwirth, Professor of Law, Head of the Department of Global Legal Studies, at the Faculty of Law of the University of Macau. He has written extensively on international law, legal philosophy, law and language, and logic, and of course, artificial intelligence. His new book, which is about the EU's Artificial Intelligence Act, is coming out soon. Today, he will speak about the EU Artificial Intelligence Act and the subliminal manipulation of human mind and behavior. So without further ado, let me present you Professor Newworth.
Good evening and good morning and good day to everyone. Thank you very much indeed for having me in this very interesting and important panel. I may now share my slides. Okay, so can you hear me, everyone? Yes?
Yes.
Does the sound good?
Yes.
Yes. Okay. So thank you very much to the organizers, especially the Cornell China Center, to have me in this really interesting panel, because it is matching exactly my interest, as Professor Xinjiang Yu said. Like I've worked on a book in the last year, and it is going to come out in August, which specifically addresses only a very minor aspect of this proposal for an EU Artificial Intelligence Act. And I will get to that very soon. First, I would like to mention that my interest in artificial intelligence came from law and language, because I wrote this book several years ago on oxymora, and I then found several commentators, experts on artificial intelligence, mentioning that it is one of them, and I quoted one of them below here. Obviously, the dualistic conception and the juxtaposition of artificial and human intelligence is kind of contradictory. And this matched my interest in particular in language and technology as sources to get deeper insights into the human brain. And then when I read the EU Artificial Intelligence Act, the proposed draft, I immediately came across Article 5, which proposes to prohibit specifically subliminal techniques. And I will explain later what this means. But it is basically a very specific article in this long draft, which plans to prohibit AI systems that deploy these techniques beyond a person's consciousness. And then there are additional elements. Of course, it has to be able to materially distort the behavior in a manner that causes also, or likely causes, this person or another person physical harm and psychological harm. Now, the problem is this is not yet the law. This is a proposal. There were many comments already written on specific issues and general issues, and this is not yet the final text. And there would be a lot to say also about what constitutes harm and how far should the scope of harm be. But I would like to focus mainly on these few questions, which are quite a lot already for 10 minutes. Namely, what is subliminal perception? And in particular, is subliminal manipulation effective? Because I think when I looked into the history of subliminal perception, from psychology via marketing, advertising to AI, it is clear that the early decades from the 1930s until maybe the year 2000, it was quite controversial whether it really works. And one specific aspect that is also very interesting is, where do we draw the line? Because subliminal means below the threshold of perception, of awareness, basically, of aware perception, below or above. And where do we draw this line? And where do we draw this line for different senses? And in this context, I also studied in my book, in particular, the role of the senses, how we studied the senses, how many senses we have. Also, that is an important question, I think, in the future, especially with regard to virtual reality, augmented reality, and so on. We also need to think of the taxonomy for the senses. And ultimately, what are the technologies that exist and that are likely to exist in the near and maybe far future that might be able to fall within this clause. And to begin with, an important information I read in a book published 2012 is that we are apparently functioning only 5% above this threshold of awareness, and 95% of this is below. So most decisions, even driving a car or walking and multitasking, we are functioning to a large extent below that level of awareness, which means if it is possible to manipulate subliminally, there is a much bigger pool of kind of information that can be manipulated to alter our thoughts and also our behavior. So if it works, I think 95% are kind of accessible to this kind of manipulation. And as I mentioned before, most people I talk to know subliminal manipulation from advertising, this so-called Coca-Cola and popcorn experiment, which caused quite a controversy in the 1950s in the United States. There was also this book then published by Vance Packard, The Hidden Persuaders. And what is quite visionary in that book is that it not only referred to subliminal techniques to advertise, to lure consumers into eating more popcorn, but also he mentioned already the possibilities to use this kind of techniques for example, promoting politicians to the electorate, or possibly also indirectly mentioning the potential manipulation of electoral outcomes, which then is infamously known as the Cambridge Analytica scandal. But I will not stay there long. This is a long story in itself, but I think what is pretty clear by now is that as Dirk Helbing has mentioned that in a book, we are now moving from programming computers to programming people in a way. So the whole question of the effectiveness of subliminal manipulation has also been mentioned or summarized as it's no longer a question whether it is efficient, it's more a question how, and depending on the context, the duration of the exposure to these kind of techniques, but it's no longer a question whether it is. There is enough proof, and I will show some examples why it seems to be working. But first, I would like to talk also about the role of the senses. And I looked into what is called psychophysics. I learned that, which is a part of psychology, trying to establish where the thresholds of perception are for the senses to even reach the mind. And here, to summarize a very long story, which also includes the whole question I mentioned of how many senses we have, I think the traditional number of 5 is too limited, clearly. And also, what is a problem that historically the senses were very often studied in isolation, so only focusing on the visual or on hearing, tasting, and so on. But we know from real life and from many interesting examples also that I could give that the senses influence each other, and that would create also a problem for drawing a line between and supraliminal perception, because maybe the threshold in seeing something could be higher when we do not hear well, or the other way around, and so on and so forth. So the senses need to be studied together, and that would be very difficult to assess then where's the threshold. Most of all, in view of this quote, which I found, which clearly I think summarizes the debate also about the threshold. There is no such threshold, because each one of us sees differently, hears differently, and even more complicated, in each individual changes in terms of the perception, like during the day, for example, you're tired in the morning or not, or tired in the evening, you see better or you hear better. So there is no absolute threshold. So actually, in this sense, the law is quite problematic, that it draws a line, but we don't know. This is a moving line in many ways. But it is still important, I think, already for that sole insight. I like this clause because it draws attention to the importance of senses and cognition and perception for law in general, for our life in general, and for AI in particular, I would say. And then, before I run out of time, just one example here is a study quite interesting. Just in videos presenting hotel rooms, to book hotel rooms, there were some experiments in terms of marketing where subliminally these emojis would be like added to these videos showing the room, and they were only there for a very short moment so that people would perceive it subliminally. And apparently among the participants, they ranked those hotel room videos which just had a smiling emoji giving a positive emotion. It went up considerably, apparently in the ranking by 63%, which seems incredible. So this is just one example of a kind of new neuromarketing and subliminal AI kind of technique, using these techniques to influence a person's decision. There would be much more, I think, and there will be much more in the future, especially coming out of new technologies and the convergence of existing technologies. So not only is it a question of advertising, it is also like, of course, we use several of these websites, applications during the day, basically almost 24 hours, if you want, search engines, the big data, when we book a hotel, when we make other decisions and so on. There were studies about the importance of the subliminal effect of, for example, flags of countries. Dark patterns is also another synonym almost for, I think, such subliminal AI techniques. And then it goes even more so into brain hacking, neuro devices like computer brain interfaces or functional magnetic resonance imaging. And when you combine all of this, the overall efficiency of subliminal stimuli is enhanced. And also, of course, the duration is very important, that you be exposed to that for a long time. So here are some of these new technologies, and there will be many more coming, I'm sure. What I find already very exciting is that there are a lot of developments in the field of the senses to replicate the human senses electronically, like an electric nose, electric tongue, electric skins even. And altogether, they will enhance, I think, the effectiveness of these techniques and subliminal AI systems. So my conclusion is very brief. At the moment, there are so many questions. I have very few answers. But the first one is, I don't think AI is intelligent and also not trustworthy in a way, simply because someone drew my attention to this problem of adversarial images, that even computers can be subliminally manipulated by some. In the middle, you see this image, which is a kind of fragmented image. To us, it doesn't look like something important, but maybe a computer recognizes, after seeing this, a dog as an ostrich. And that is, I think, a scary idea to me, at least, that it will be possible to also trick computers and cameras. And we know a lot from illusions of the senses. There was this dress going viral, which people saw gold or white or black and blue. So in terms of evidence before courts, I think even maybe surveillance images might not be always reliable. And another problem is, of course, with the enhancing all these techniques. I think that Orwell's prediction in 1948 is already outdated, and it's not that private life will come to an end with all these technologies. It's probably private thought that will come to an end. And this is why I think we need a global debate on these dangers, on the technologies. It has to be interdisciplinary. I mean, I learned a lot, and I see how difficult it is to engage even between the different fields, even within law and other, and also on these effects on the mind and on our behavior. And I think my time is pretty much up. So I stop here. I hope I can clarify some more things maybe then in the QA. Thank you very much.
Well, thank you very much, Professor Newworth, for that very interesting presentation. Yes, sorry, things like integrating computer with the human mind, mind reading, brain hacking, and so on. Things like that are really, really dangerous, right? It is really not a good thing to do, and it would be detrimental to individuals as well as societies as a whole, right? And but Elon Musk was one of those people who were actually promoting regulating AI at a very early stage, right? But at the same time, he was also promoting this kind of integration of brain with the computer and so on. So that's a really difficult question there. I have a question for you. I know that the EU's AI, and which is the very familiar term of yours, has actually classified the management of risks of the different types of AIs with unacceptable, high risk and limited risk and low risk and so on. So I wonder that if that kind of classification could actually alleviate the problems that are associated with this kind of subliminal use of AI.
Yeah, thank you very much. This is difficult for me to answer in a sense when it comes to the subliminal dangers that are looming behind different categories of kind of technologies. Like I said before, I think it has to be related to the context, to also like clearly the duration of the exposure. And then ultimately, what is the subliminal message? Is it a harmful one? Because I think I looked at some examples that the Commission published, like low risk would be video games. But I think we know, for example, from violence in media studies and so on, that even, video games may be kind of dangerous and high risk. Or thinking about some precedents in the United States, there were in the 1990s these lawsuits against rock bands for apparently backward masked messages in rock music. I mean, who would say that rock music is a high risk product? Or but when the wrong message is encoded in it, it can become lethal actually. So I think, of course, the classification is necessary. We need to promote the dangers and the awareness about the dangers and classify it. But we need further debate clearly, and also the input of experts from this psychophysics, psychology, to really understand what the subliminal dangers are here. So the problem is the AI Act also has a clause for updating the definition of AI. And this will be rapidly evolving on a daily basis. And I think we need almost like a parallel debate on solving these issues. But I fully defend Article 5. I think it's a good starting point for a debate, and also these different risks create the awareness and the necessary debate. But I have no definite answer to what is the best approach yet.
Okay, thank you very much. Thank you very much. Our next speaker is Xiaoping Wu, counselor in the Intellectual Property, Government Procurement and Competition Division of the World Trade Organization. Ms. Wu undertakes work in the area of the WTO agreement, that is TRIPS agreement, with a focus on patent policy and the legal issues in the sectors of biotechnology, information and communication technology, and also emerging technologies. She's also responsible for review with WTO members' national IP legislation and the transfer of technology to least developed countries. Today, she will speak about reflections on intellectual property related policy and the legal issues arising from the interaction of artificial intelligence and the intellectual property rights. Xiaoping, please.
Thank you very much, Professor Yu. So just make sure you can see my slides. Okay.
Yes.
Okay, great. So good morning, good afternoon, and good evening to all. Thank you, Professor Yu, for your very generous introduction. Also, thank you for China Center in Cornell inviting me to this very interesting conversation. I think we are all very much looking forward to. As a Professor Yu just mentioned, what I'm going to do here today is to share with colleagues my personal reflections on several IP-related policy and also the legal issues emerging from the interaction between the IP and AI, particularly from the perspective of international organizations. But in the very first place, I would like to emphasize today I'm here in my personal capacity instead of as a WTO officials. So what I'm going to present is not meant to represent the position or the opinions of my organization and of course its members. So first of all, let me very quickly summarize several key legal issues currently subject to very hot debate in the international IP community. As like Professor Liu, I don't have any ambition today at any rate to provide answers to these questions. Instead, I would like to summarize these questions and policy challenges, and then further to share my very initial thoughts on how to address this question and challenges, from the different perspectives. So the first question is whether or not, AI can be inventor or author for the output, the AI generates or automates. So including the inventions, painting and written work. Or whether or not only human who builds and use and train AI can only be the inventor or author. I think so far in maybe I can say in almost in all the jurisdictions, a nature person has to be the inventor, has to be the author, and the natural person has the very first right, to the patent application or to the copyright. But as you know, last year is a big news. In 2021, the Artificial Inventor Project, led by Professor Ryan Abbott, successfully obtained the world first patent in South Africa for an AI generated invention, and in which AI is first time is recognized as inventor. And then later on, the federal court in Australia, they also the judge made a decision, said AI can be an inventor. So the second question I want to raise is about a patentable subject matter, whether or not AI generated invention should be excluded from the patentable subject matter, or whether or not algorithm and AI application should be excluded from the patentable subject matter. So in principle, the current patent system or current IP system is supposed to protect invention rather than discoveries, right? So it's often, in practice, I have to say, it's often very difficult to make a distinction between inventions and discovery. So this kind of challenge, become even more difficult, in the context of AI-related invention. So the third question is about the disclosure requirement. So the current patent system require all the patent applicants or inventors to disclose your invention in a manner which is very clear and in a very clear and complete way, will enable the people in this technology field, with ordinary knowledge and skill, to carry out this invention. So now the question is how this requirement, this disclosure requirement, apply to AI-generated invention. And another relevant question is what will happen if a patent examiner, they use AI to conduct a patent examination during this, whether this patent invention is patentable or not. So the last question is about training data. So the training data, I think there are at least, I see at least there are three different, stakeholders. So one is the owner of the data, the training data. This owner can be a group of millions of people. Each of them, they made a very small, contribution or have very small share of the value of the whole, training data set. So now, and the other is the processor, and the other is the user of this data. So who are the real owner of the data? How this the owner of the data as such can benefit, right, from can share the benefit, from the arising from the use of this data. So I think so far at present, nobody has a definite answer to all these questions. But the very first issue we have to consider is whether or not we can address all these new questions, within the existing intellectual property system. As you know, the existing IP system is we call the human-centric, system, which is actually definitely was not designed for the AI era. So should we adapt or clarify the current system and then make it, for the new issue arising from the AI? In other words, is there any need for us to reinvent the wheel in order to address all these issues I just mentioned before? They believe, say, the current IP system may no longer be relevant. So we have to make a dramatic, reform of this system. So here, before, I think before we answer this question, I will suggest, looking back into the history and what we can learn from it. As we all know, the current IP system has been there for many centuries, right? There are now 3 international IP laws, Paris Convention, Berne Convention, and the TRIPS Agreement. This is monitored by my organization. So thanks to these 3 international agreements, so nowadays, I think national IP law are often very, very similar. So Paris Convention and Paris and Berne Conventions, they were established, back to 1883 to 86 and revised several times. And the TRIPS, entered into force in 1995. And the TRIPS use so-called, we call incorporation scale. That means the TRIPS agreement refer to the pre-existing international convention, Paris Convention and Berne Convention. And in the meantime, the TRIPS negotiate some called plus element. That this plus element do not exist in the pre-existing international agreement. So one typical example I want to mention is in the area of copyright. So the TRIPS agreement actually added 2 types of the protected subject matter in the TRIPS agreement. So one is a computer program and the other is database. So under the TRIPS, which is not covered in the Berne Convention, is a computer program, no matter in source code or in object code, should be protected under copyright law. And for the database, database also should subject to the copyright protection. Database and other kind of compilation of the data or other material should be protected. And such kind of protection only limited to database per se and not extend to the individual pieces of data which contain in the database. So with this, just because of time reason, I can't go through all this plus element. So this is just a typical example I want to share with audience today. So through this typical example, it seemed to me that there are many resources actually available to the legislator to adapt and clarify the current IP system to accommodate the new AI-related issues. So now I just want to further support my initial thoughts is about the training data. So now we discuss a lot about the training data, who own the training data and how to protect the training data. So my observation is, do you see there's some similarity between the protection of training data and the protection of the genetic resources and the traditional knowledge, and between the protection of training data and the collective copyright, management system? So I don't want to give a very quick conclusion on my position, but I hope I raised a right question to all the colleagues and panelists. So it seemed to me we don't, at least at this moment, I don't think there is need, to reinvent the wheel every time when faced, with a new challenge brought by the developing technology. So Before I move to the policy issue, I'd like to very quickly present WIPO, WIPO, of WTO's sister organization. Their recent research conducted in 3 years ago. It's on the trend, in AI technology. I think this will provide all of us with some statistical background. I think which is extremely important for us to have a policy debate. So this research show from 1960 to 2018, nearly 340,000 AI-related inventions have been filed patent, and over 1.6 billion scientific publications have been published. And the AI patent family has grown annually by average of 28% between 2012 and 2017. So in the meantime, the ratio of the scientific publication to the patent application has decreased actually from 8 to 1 to in 2010 to 3 to 1 in 2015. So this actually very clearly demonstrates, the movement from the conceptual research of AI to the use of AI in the commercial and non-commercial products and services. So another is among all these patent application, we can see 1/3 of publications have been submitted in more than one jurisdiction. And the top first patent filing office are China, US, and European EPO. And the top patent office for the second filing are the US, China, and EPO. Here, I don't, because I don't think I have time to explain the EPO, why I mentioned EPO, not Germany, I can explain later. So, so to me, the race in the patent application and also scientific publication show, in these beautiful graphs, but a product of a great, investment in the development of this technology and their commercial use. So it's just not just the number of the patent application. Actually, is the behind this number of the application is massive, financial, investment in this area by the private sector and even by the government. So then this actually lead me to the policy issue. So here I just want to use a quotation by Abraham Lincoln. I think this is familiar to a lot of colleagues. So the US patent system adds to the field of interest to the fire of genius in the discovery and the production of new and useful things. So national IP policy, I think, has been played very important, and it will play a very important role in this area and to shape the direction of the AI evolution. So we actually have observed, the government have started to engage in AI regulation from different perspective. So from the IP perspective, I think you see in and the very typical example is Japan. They amended their patent law in 2018 and becoming the very first country in the world to do so and enable the text and the data mining by introducing a new article in its copyright law, which authorizes text and data mining by all users and for all purpose in both commercial and non-commercial purposes. And this amendment, I think, is meant to ensure, the Japan's legislative environment will be fully supporting, its national AI policy. In the meantime, I think all these graphs also reveal to me the uneven capacity and also the technology gap in this area between these top three, you can say top three country and the region, US, China, and Europe, and between these three countries and the rest of the world. So I think it's very reasonable for us to predict this technological gap will be further deepened in the future. So I would like to conclude my presentation actually by posing a question to my fellow panelists and also all the audience. What kind of the IP policy should country which are obviously not IP leader, they should follow to address the challenge in the near future? With that, I conclude my presentation and give the floor back to Professor Yu.
Thank you so much, Xiaoping, for this brilliant, informative presentation. You have raised so many questions, which I believe are very important questions, but we are not able to answer all those questions here. And the last question you posed, I guess, probably you are in a better position to, provide answers than, but of course, a debate at a certain level, like, at a global level or even, national level would be very beneficial. You mentioned the term EPO, and which sounds very, very interesting. So I wonder if you could just elaborate a little bit on that.
Sure, of course. So for the EPO, it's like a regional patent office. So when we talk about a patent filing, in Germany, so it's just the number in Germany. But if we are talking about the EPO, the number of the EPO, so basically this patent can be filed in all the EPO member states. So if you look at individual European EPO's member states, so the number can be very small. But if you put all the EPO member states together, the number together, so the patent filing number can be very impressive. So when I made mention, this top patent filing office. So if you just look at the Germany, this German can be maybe after, Japan, after Korea, But if you look at the EPO number together, I think this is among the top 3 of the patent filing, both the first filing and also the second filing. I think, Professor, you're on mute.
Thank you very much. Thank you for that elaboration there. Because time is constrained, we will have to move on. So our next panelist is Guo Rui, Associate Professor of Law, Institute of Law and Technology Researcher, and Director of Center for Social Responsibility and Governance at Renmin University of China. He researches on corporate law, financial regulations, human rights, and the ethics of artificial intelligence. He holds an LLM and SJD degree from Harvard Law School. He's a member of the Subcommittee of Artificial Intelligence, National Standardization Committee on Information Technology. Today, he will speak on stereotypes and AI fairness. Professor Guo, please.
Thank you, Professor Yu. Thank you again for inviting me to this wonderful event. And I'm honored to join this distinguished panel. So in the interest of time, let me directly dive into a hypothetical case. A person with a physical disability, A, submits a resume to company X for a mid-level management position. The company uses an AI-powered HR system to screen the resumes. The HR system relies on a deep learning-based algorithm to make decisions, and A's resume is automatically screened out. In training the HR system, the company uses the historical data from the past 10 years. Let's say certain metrics were pulled out by the algorithm automatically from the resumes. Let's say the records include on-time attendance, time away from the office during working hours, rating of the applicant by previous employers. The training data included 50,000 employees' resumes over the past 10 years, including 25 of the persons with disabilities. Because A's resume was screened out, A filed a lawsuit in court claiming that the company used an HR system that discriminated against A. So how do we deal with the case? First, let me say that in the context of our current AI technologies, how to find out and deal with discrimination is a new challenge. Compared to the traditional forms of discrimination, AI discrimination is often more difficult to detect and more difficult to address. It is therefore a very important topic for AI fairness. So the case I mentioned is from a recent research I have done on discrimination against persons with disabilities. So let me save all the kind of citations and reasoning process. Let me go directly to the three factors that we find out we should pay attention. First, the data. If the data used to train the AI model contains biased human decision, the bias can be passed on the model eventually. Second, if the data used is not directly related to the final decisions, but merely a proxy for the more direct data, then the decisions related to the protected group may have a higher rate of errors, which ultimately leads to discrimination. Three, if the data used lack representation of the protected group, then the results are likely to err, and the errors will lead to discrimination. So that's our findings. Let me just say the discrimination shown in this case and all the three important factors we think we should pay attention to is fundamentally due to the widespread stereotypes of disability. In the employment context, the stereotypes of disability leads to a negative impression on the capacity and willingness to work. And it goes without saying this might take place without people realizing it. I very much like our first panelist's presentation, because sometimes these negative consequences may exist without we realizing it, right? But let's see maybe some of the details. The first thing I want to mention is that maybe the HR system uses the company's employment data from the past 10 years. So when you look at the sheer number, it's large. But when you look at the hiring decisions, it's only 0.05% of the total employees. So without satisfying the condition of independently identical distribution, the algorithm's hiring decisions are more likely to be mistakes and leading to the algorithm discrimination we look at here. Second, some of the proxies that the algorithm use. Let's look at the on-time attendance. It looks like an objective index, but in fact, when we think more deeply, this may relate to maybe the not so ideal condition of the local public transportation system, which may not well designed to accommodate wheelchair users. Therefore, the on-time attendance rate may be affected. This has nothing to do with the willingness or capacity of the job applicants. Likewise, time away from the office during working hours may also due to the lack of restrooms, right? So if the employees need more time to go to a place further away to use a restroom, then it may also affect these indexes. If this algorithm also used the training data for the previous employers, we cannot exclude the biases already existed in the reviews. So hence we find all these problems. So as we have repeatedly seen in my disability law clinic classes, and in various other occasions. Disability may not be only problems confined to persons with disabilities. When we diagnose the problem, we always find that more widespread problems exist. Only when persons with disability are affected, they're less likely to be able to deal with them. So in this sense, when we look at problems through disability, disability is a place where we find out problems that exist in wider society. What we find in the disability context is the difficulty to deal with and uproot stereotypes, because persons with disability is more likely to suffer from the worst of tech failures and ignorance. If stereotypes continue to exist, they may create problems here and there. So we always have to deal with new challenges. So the consequences of discrimination that occur for people with disability, in a sense, are more simply more concentrated and intensified manifestation of problems related to AI fairness. And if we don't respond, if we don't respond well, these consequences sooner or later will take place in larger society. So this is why I'm interested in disability issues, and through this issue, I think we should pay more attention to AI fairness. So I hope this analysis of this hypothetical case is inspiring for us to think deeply in AI fairness. And that's all for my presentation. Thank you.
Okay, thank you very much, Professor Guo. I think you approach AI issues from a very important, a unique perspective angle. It is really, really sad that people, some members of our societies are not able to benefit from the AI advancement, and of course, AI is like a double-edged sword. It cuts both ways. It's beneficial as well as sometimes could be detrimental, right? So I wish that we had more discussion in this field, disability and intelligent technology and so on and so forth. I think China is actually moving ahead, right, in this direction. In your view, would China consider making a regulation that relating to protecting the vulnerable people or social groups with disability, people with disabilities? And if so, what would be the most challenging issues involved? For instance, given that digital literacy is still some kind of luxury for the great majority of the Chinese people.
Thank you, Professor Yu. That's a very important question. So the current regulation has not been focusing on, specifically focusing on the persons with disability, but there are really good regulations targeting at creating, getting rid of the digital gap for the aged group, so for the elderly. Recent regulations has been emphasizing this, and some of the larger, I think all the large tech platforms have been making improvement to accommodate the elderly group to use their products. I think it's a really good direction. And also, I think China is one of the parties for the UN Convention on its acronym CRPD, to protect the rights of the persons with disability. And I think China has made legislative improvement after joining CRPD. One of the recent projects we have done, and actually not long ago, it's May 5th, and China joined a Marrakesh Treaty, which is in the copyright field, Professor Xiaoping's field, to enable the visually impaired group and also those with print those with problems, difficulties in reading the print version of books and magazines and newspapers. I think these moves will eventually lead to a better awareness of disability and for the society to improve the awareness on disability. And I think that's the biggest challenge. I think awareness is the biggest challenge, and that's probably the most important in the long run to help the vulnerable group. Thank you.
Thank you very much, Professor Guo. Our next speaker will be Linhan Zhang, professor at the China University of Political Science and Law. She was a visiting scholar at Cornell Law School in 2016, if I remember correctly. She's a member of the Council of the National Network and Information Law Research Society, and a group of national AI ethics and guidelines, and so on and so forth. She actually is a member of quite a few organizations at the national level. She is a theorist as well as a practitioner. She has published extensively on cyberspace law and algorithmic governance. She has published a book entitled Research on Total Liability on Online Virtual Property and Governing Power. And also another book is called Governing Power, Regulation of Algorithms in the Age of Artificial Intelligence. She will speak about algorithmic supervision in China, fighting for records, examination, and accountability. Professor Zhang, please.
Thank you, Professor Yu. Can you hear me?
Yes.
Thank you. Thank you for a gracious introduction. Hi, everyone. It's my honor to attend this panel discussion and share my views with all of you. And my topic today is algorithmic exploration in China, fighting for record, examination, and accountability. I will say a few words about the background and the regulatory practice of algorithmic supervision in China, and provide some understanding of the driving forces behind China's new rules for regulating artificial intelligence. Today, my presentation will concentrate on the algorithmic regulation, which I think is one of the most important fields in AI regulation. In March 2022, the Cyberspace Administration of China has a new set of rules for regulating internet recommendation algorithms, which covers everything from like TikTok to search engines. I noticed it was translated into English 12 hours after the draft was released in August 2021. There were also quite a few articles and reports about this law. So why is Chinese government concerned about algorithms? As we all know, one great feature of Chinese legislation is to respond to social changes and public attention. I think three big events may have promoted the making of the new regulations on algorithms. First, the Ant Group, the Chinese fintech company that was about to launch the world's largest initial public offering, was asked to cancel its IPO 48 hours before the debut. The reason given is that the internet financial system is a conflict with the traditional financial and banking regulatory system, which may cause the unaffordable systematic risk. After that, China shifted its policy towards digital economy, which is actually following a global trend. Second, two major food delivery companies in China have been criticized for using smart algorithms to set up routes and impose tight deadlines for delivery drivers, leading to many traffic accidents. As most of these drivers are not full-time employees, they cannot receive Social Security or compensation for work-related injuries. The absence of formal legal protection for drivers results in many labor disputes. Thirdly, there were several cases which attracted public attention in 2020. The Chinese e-commerce platform collected many consumers' data, and they employ smart algorithms to price indiscriminately from the Chinese consumers. So Chinese hide-hailing companies see that the prices vary because of the fluctuation in traffic. But some studies and news reports claim that apps may offer different prices based on the factor, including the ride history and the phone a person is using. The platforms argues that it's not my decision, it's a decision made by algorithms, and we are innocent. So just like unveiling the company's will in corporation law, Chinese government wants to unveil the algorithmic will to protect the labor force and consumers. After these three events happened in 2020, a roadmap of algorithmic regulation was brought up. In September 2021, last year, 9 ministries and commissions jointly issued a notice on guidance on strengthening the comprehensive governance of algorithms for Internet information service. And this is the second year. And the law recommendation algorithm is the first step of a comprehensive algorithmic regulation. It's the work for the cyberspace administration for China. So this is also explained why the law called the recommendation algorithmic regulation. The cyberspace administration is mainly responsible for the safety of Internet information content. Personalized recommendation algorithms are used extensively by social media apps for content recommendation and targeted advertising. So the law uses this name ensure that they are in line with the constant job responsibilities of the cyberspace administration. But actually, if you read the law, you can find that the law regulates much more than recommendation algorithms. The law defines the recommendation algorithms into 5 types, like the algorithms set prices, control search results, recommend videos, and filter content. So actually, I think the law almost covers all the kinds of algorithms and platforms. There have been a lot of online discussions saying that the law is totally new. In my view, this is not as radical as the online discussion tends to inform us. It's more like a collection and a combination of algorithmic clauses in different laws into one law, and follow the trend of the world AI governance. It includes the requirements from personal information protection law and the data security law, and some previous regulations published by the cyberspace administration. All of this form a new set of regulations, like limiting use and misuse of the recommendations algorithms. If we want to know is there anything relatively new and original in this law, I think this is the algorithm filing system. First, the legislation established the algorithm filing system. This is also part of the title of my presentation today. Filing for record is kind of registration, and it does not have the effect of administrative license. The larger intent of the government here, I think, is to figure out exactly how many algorithms are now being used in the platforms. So what is the content of the record? In my opinion, this is what the design algorithm intends to be. The content to be filed includes the name of the service provider, service form, application area, algorithm type. I think one of them, the most important one, is algorithm self-assessment report. So the government will go back if there are any serious consequences. The government will go back to check whether you have reasonably forcing the flaws in your algorithms, and whether you did enough tests to find it, to find it. And secondly is the algorithm examination part. How much access to the code does the cyberspace administration get? Some of the regulations are considered technically challenging to the practice. In April 2022, yes, last month, the Cyberspace Administration organized the algorithm examinations in several big technology companies. These examinations focus on checking corporate algorithm compliance and algorithm security capabilities. Do the companies have the algorithm security capabilities? Do they have the algorithm evaluation standards and system? Or do the companies have some emergency response system and so on? Just like you can imagine a fire administration in your neighborhood, regular checkups for the fire prevention, whether you have a fire detection, make sure your water supply system works. Also, there are people doubt whether can the government ensure that what kind of stuff isn't happening in the algorithms and not in the platform. The cyberspace administration actually has a strong technical department and sometimes cooperate with the teams from Chinese academic science. They do not have to access the algorithm code because the code actually is not essential to the examination. The algorithms code are continually changing every day. So actually what is essential to the examination is to do the necessary tests. They just input some data and to check whether the algorithm will result some discriminatory output, like not fair and not reasonable, for instance. And third part is the legal responsibility and accountability of algorithms. Actually, under China's regulations, violators who refuse to correct the issues or whose action have had serious consequences are liable for fines. It's between like $1,500 to $15,000. It's really an insignificant amount for the larger technology companies. So besides the fines, companies that violate the rules could be barred from enrolling new users, have their business license put, or see their websites or apps shut down. However, I think the essential punishment is not the fine, all the things we cite above. It's about the company's market value lost. Some of the big technology companies in China have been through the crackdown of share price in stock market after the administrative penalty. So this is the outline of the algorithm separation system in China. Actually, I think China shares much similarity with Europe and US, while maybe the filing system and the examination is relatively the new practice. I think also in China, the regulation is a combination of the regulation and self-governance in the algorithms. Thank you, Professor Yu. This is
Okay, thank you very much, Professor Zhang, for a very informative presentation. We know that China and India actually are the two Asian countries that lead the way in making AI regulations. In recent years, China has made so many individual regulations and rules, but somehow we still don't know much about the how these institutions actually function and who is responsible for what. So I wonder if you can just use next 2 or 3 minutes to say more about who is who and who does what in China's AI regulatory framework.
Yeah, that's a very good question. Actually, there are many mysteries in ministers in China. Actually, there are many departments in China government. Yes, to do. And over the past 3 years, the Chinese government has rolled out a series of policy documents and departments who
Sorry, we have lost her.
participate in AI regulation and algorithm regulation. I think there are three departments. We can see the cyberspace administration focus on the content of the internet information and the algorithm regulation. And another important department is the state administration for market regulation. It works on the antitrust and the internet platform governance. And the third one, I think, is the Ministry of Science and Technology. It's responsible for establishing AI ethics and publish the guiding opinions for AI ethics. Yeah.
Okay. Thank you very much, Professor Zhang. Thank you. Well, with that, so what? Okay. Well, let's just move on. Since all our presenters have done their job, now let's open the floor for additional questions. So for those of you who are attending, please submit any additional questions for the audience through the Q&A tool in Zoom. While Professor Hua is retrieving the questions, let me just ask all the panelists here one simple question. I guess we all are aware that AI needs to be regulated, but we probably will not agree as to what level should that be carried out, or whether there should be a domestic or local regulation, or there should be a regulation at the global level. So I would like to hear from all you guys. Professor Newworth, what's your view?
Thank you very much. Well, I would say, of course, with my love for oxymoron, I would say it should be local, especially from Macau's view as a special administrative region of the People's Republic of China, but also a member of the WTO. Yes. It shows how complex the world is now from a legal perspective. And I just would like to mention that UNESCO also adopted in November a text on the ethics of AI, which shows that there is clearly also a global concern and a consensus. So, of course, the law should also embrace the local kind of particularities and be flexible in that sense. So clearly, both, I think, is needed. And obviously for the fact that these technologies transcend territorial borders, we need to cooperate. And the best way it was put is by David Held in his book Cosmopolitanism, which he called the paradox of our times, is that we have more and more global phenomena, but we only address them locally. And the pandemic is, I think, one of those cases which should remind us with other problems, including AI, that we have to cooperate more. And in the end, I think the issues are pretty similar everywhere, but they manifest themselves a slightly different way, but definitely both, yes. Sorry.
Thank you very much. Xiaoping, what is your view?
Thank you, Professor, for this really very good question. Actually, from my perspective, basically focus on in the IP area, I think it might be premature for the national legislator to make any kind of legislation movement. Of course, in my presentation I did mention Japan made the amendment of its copyright law. So I think maybe at this stage, national judiciary will play a very essential role, in dealing with all the new issues. Because I think through all this judicial decision, I think we'll give some space for the national legislator, even for at the international level. I think it will provide maybe enough, national experience, to learn from each other and to see the next movement, whether to the legislation is necessary. And I think that this kind of trend, we can see very clearly in the other IP related, issue. This is actually my passion. It's about IP and standard in the information and technology communication technology sector, how to address the intention, the attention between the patent protection and the standardization. So we have already observed a lot of judicial decision, which actually is a very controversial judicial decision have been taken, in the different countries. I think this will provide first-hand, solid, material information for legislator to have further reflections. Thank you.
Okay, thank you very much, Xiaoping. Professor Guo, what's your view?
Local versus global. I still think disability may provide us a very interesting angle to look at the problem. I think we all face some common challenges, like I think the broad adoption of UNCRPD is reflect that, but also some of the more local problems, like specific stereotypes in one society, may be intensified in the new technological context that may need the local to be responding more actively. So I think both are needed and to deal with the bigger challenge. Thank you.
Thank you very much. Professor Zhang.
I think it's a very good question. Actually, I think all of us hear the word like the Brussels effect. Actually, it is the most strict level, like in Europe, like the GDPR provided protection of personal information. So all the countries have to follow up the protection level of the personal information. Like in China, 3 years ago, we do not have any laws about the personal information protection and data security. Actually, after 3 years, the legislation process that China has been the most strict jurisdiction in the world. So I think maybe we can see the question at global level will follow some local level, especially if the digital economy here is very developed. It's developed in this area. Also, I think the local level is very special for this country. In China, the information security may be the most important thing to make sure the website security or to be protected the most strict. So it's different from US and Europe.
Good. Thank you. It seems that we have consensus that both levels are needed, right? Universal as well as local, global as well. Professor Hua, do you have any questions?
Oh, I think right now there's not yet questions coming in from the audience yet.
Okay, if that's the case,
and
yes,
encouraging
Professor Newworth,
who are in the audience
okay,
to submit.
Professor Newworth, please.
I would like to maybe try to answer the question raised by Ms. Wu Xiaoping about the future copyright or IP regime. I don't really have an answer, I guess, but what my observation is and what I've learned from looking at this specific aspect of the AI Act of the EU is simply that we are living more and more in an increasingly complex world, where we should also look more at indirect effects of one regime on another. And I'm sure you know much better than me, actually, in the WTO, how complex the different regimes are, services and goods and now intellectual property, and how they affect each other. So I think that the true challenge today in terms of regulation is to agree on something, because we can go with this way for a long time still if we agree on it. Or if we can create something better because we agree on it, it would be probably better. But we need a very broad debate, and I think a very broad view, and also to tear down probably some of the classifications that even within law, because they hamper our view on the complexity of the underlying issues. And AI, I think, will be a strong reminder that each whatever we do in one area will have an impact in another. So, but I don't know, this is probably not much of an answer, but I tried. Thank you.
And now we have question coming in. So one question is from Michael, who's a student who works on algorithm and AI. And his question is, I'm just reading off the Q&A page. I have a general question about the role in AI and its creator. So it is true that AI is predictable in a large, big picture, in his opinion. But looking at the trees instead of the forest, we couldn't tell every step within the decision in AI. So AI is now taking more important roles. So under unpredictable circumstances, who should pay for the misjudgment led by AI? Its creator or AI itself? Is AI capable for taking the responsibility?
Okay, very good question. Yeah, please. Who wants to answer that?
Let me volunteer to provide the very preliminary response. So in my research, I actually think the most, so the thing that distinguishes AI from previous technology is exactly what you described in the situation. We have two problems that is almost impossible to solve, that prevents us from completely to deal with the problem. So one of the problems is the problem of causation. So we cannot predict each step. We cannot see how far reaching the consequences will be. As a response from a governance perspective, this related to my work for the standardization authority. So one of the principles we propose is the principle of accountability. Because we cannot predict all the people, all the things that AI technology will influence. So we make all the parties to be accountable to the results. And we try to create a governance system that those who are negatively impacted could be easily flag the problem and provide feedback. So we truly need a more flexible governance system in order for us to apply the accountability principle. So that's a very preliminary answer. Thank you.
I think we actually have a lot of questions coming in. The next question is to Professor Newworth. You mentioned the AIA, UNESCO drafted this AI instrument, but it is not an international agreement. It is kind of a model law or soft law. So how to make those AI ethics principles coded in the legal texts? Has EU made a good example? So
I think correct. Even the EU Act is not yet in force. So at the moment, it's in the stage of debating. And but what I meant, UNESCO is another example that there's a concern about, a consensus about the concern. And that's already a good step. A huge problem will be also, of course, if we would envisage such an agreement, binding one, which organization would be best or most competent to do so because of the completely complex and transdisciplinary character of AI. It could be any international organization. And so it would really, that in a sense challenges our existing, I think, international legal system, which is why I said the fragmentation should be addressed, because everybody will be affected by it. But it's a step, at least, to move forward, to have already some consensus, even on some soft law clauses. Yes.
Thank you. The next question is for Xiaoping, Dr. Wu. Is it possible to establish collective ownership for the AI training data?
Yeah. Yes. Hold on. For this is a really very good question. Actually, before I answer this question, maybe I just add a few things, to Professor Guo reply to the question raised by Ms. Yi about who should pay for the misjudgment or led by AI? I think this is really a fascinating, question. And this question is very much linked to my presentation about the inventorship, ownership, and also patentee, of the AI generated invention. So my preliminary thoughts is all this should be connected to each other. If you want to claim to be an inventor or owner of an AI invented, AI generated invention, and then you should take all the legal responsibility, right, including the misjudgment. So my point is all this kind of issues should be connected to each other, and you cannot isolate, one issue. You just talk about inventorship and ownership, and you just like put aside, the question you raised about this misjudgment, who take the legal responsibility for this misjudgment. So this is what I want to add to Professor Guo said. Regarding the question, the other colleague mentioned this collective ownership, but this is exactly my point, my, I can say suggestion on the protection of training data. So we do have this kind of existing system we call the collective, copyright management system. All the copyright owners, they put together their copyright work, and then there's an organization, association, they manage all this massive, copyright work, and then collect the license fee together, and then distribute, the license fee fairly among all the owners. So I think this model can be, at least we can learn something, from this collective copyright management model. But I think there's still a lot of legal issue because one thing I already have observed is for this copyright collective, the number of the copyright owners is still quite small, right, compared to the training data. And also the identity of copyright owner is quite very obvious, in the collective. But for the training data, who are the owner of this data? It can be a lot. In most of cases, I think we don't know who is whom, so this could be one of the challenges. And the other question about, I think I can't remember who raised this question in the Q&A chat box, is about the global regulation. I think from the IP perspective, it's a dream. It's a dream of all the international IP experts, to have a harmonized, global regulation. But I said it's a dream. Dream is dream, and in practice, in real life, it's based on my almost 25 years experience in this field. I don't see any kind of possibility to reach agreement on this global regulation. One reason, actually, I already mentioned in my presentation, because of the huge gap, the gap of the technology gap, and also the regulation gap, the legal system gap. So, and maybe you can say all this technological gap and the legal gap because of this economic, different level of economic development. So I think given all these gaps, between, the countries, and also now because of this geopolitics, the mixed together, I personally feel this global regulation is very, very difficult. And if maybe I say very unlikely. Thank you. Hope I exhausted the question.
Thank you. We only have 2 minutes left, and then the next question seems like it takes several weeks of lecture to answer, but let's see. So the question is actually asking for a summary of main differences among the regulation of AI by US, EU, and China. And it's actually a pretty nice summarizing question if the panelists can answer in now only 1 minute.
I'm not in the position to answer it completely, but I don't know, maybe I'm wrong. My only observation so far is that the EU Act is at least trying a comprehensive view on AI and not so much a sectorial approach, but I might be wrong because I'm not fully informed about the US and China in that respect.
Professor Yu, do you want to make a brief comment? Oh, you're muted. Oh, you are, let's see. You're muted, Professor Yu.
I mean, that's a very difficult question. It's very hard to answer. But from my perspective, it seems that the EU actually adopts a very strict regime in regulating AI, focusing on individual rights, human rights, and so on and so forth. While the American approach seems to be try to strike a balance between innovation and the protection of privacy. While the Chinese perspective is mostly, also try to strike balance there, but probably leaning towards governance than, protection of privacy and so on and so forth. But I don't know if that is correct. That's my general impression. Okay, thank you very much.
Thanks. So we are very quickly getting to the end of our webinar. I feel like this should be a half-day event because there's so many thought-provoking topics. So we really hope to continue the dialogues in the future. And then also hope those of you in the audience will be interested to follow future events by the Cornell China Center. So thank you, Professor Yu, and thanks to our great panel. And then thank you all for joining us today.
Thank you. Thank you very much. Thank you.
Have a good day.
Thank you very much.
Nice
Bye-bye.
All the best. Yes.
Thank you.
Bye-bye.